What's unique about vehicular cases in Texas is that the system is designed to protect officers, and it's designed that when an officer, for example, pulls somebody over and smells alcohol, that all the dominoes begin to fall the officer's way from there on. There is a presumption of guilt. Put them in handcuffs, put them in your patrol car, take them to jail. That has led to very stiff penalties for vehicular crimes cases, and specifically those involving intoxication. The officers are very aggressively enforcing these laws, and prosecutors are very aggressively prosecuting these cases, and that's why we see it goes from a first offender punishable from probation to 6 months, second offender probation up to a year, third offender 2 years minimum, could be a probation, or 2 years in the pen up to 10 years in the pen. Right? It's an extremely harsh punishment scale. And if we talk about injuries in the crash, and then it automatically jumps to a felony. Or if there's a child in the car. These are very, very strenuous laws that are coming down from the legislature. We're seeing it from the prosecutors, and we're seeing it from the officers. It's just a harsh environment. So likely the first thing that's going to come through your mind is, I don't want anybody to know about this. I don't want my coworkers to know. How do I keep my boss from knowing? I don't want my family to know, my parents to know. And to a certain degree, you got to know on the front end that that's one, it's normal, of course, but two, nothing has happened that's been set in stone yet. Nothing that has happened, so long as you're contacting me as soon as you reasonably can and pre-trial, nothing that's happened that can't necessarily be resolved in a way that's the best possible way for you. But the earlier, of course, the better. From the time of that time that arrest occurred. The arrest on a DWI typically occurs, the way the legislature wants it to occur is when an officer reads what's called a DIC-24 form. And once that DIC-24 form is read, you need to know that you've got 15 days from the day of the offense to get to me so we can contest the suspension of your license. Beyond that, what you need to know is that you are presumed innocent, despite the way the cop treated you or the way things have gone or interactions you may have had with the prosecutor. You're presumed innocent, and that everything from here on out is about holding the state to its burden and keeping your rights intact.